topic. And it's really not easy to take a look into all aspects of the Hague-Visby rules. If you were to reassess it in some depth, it's probably going to take us hours to do that. The reason why I have chosen this topic is for two reasons. We have seen over the last decades so many changes in the shipping practices. And now we have got mass on the horizon. We again have got this very important question of whether we should keep up with what we have got or whether we should actually really take some very bold steps to change the current regime.
Okay.
Obviously,
sorry to interrupt. Can you try to play the slideshow? Because we only see part of your presentation, I'm afraid. And if you play the slideshow, that's going to be...
Do you think so? Okay, let me just see if I can...
Here?
Yeah. Is it? Okay. Right.
Yes, wonderful.
Okay,
Thank
fantastic. So the major thing, therefore, is to have a think about where are we now, reminding ourselves of the fact that we have seen two failed attempts to change the current system in place, and Rotterdam rules, very ambitious, nice blend of civil law and common law, but unfortunately we haven't got many countries ratifying that. So my main purpose here is to think about that issue. So should we change or should we keep the status quo? For us to have some assessment of the Hague-Visby rules, I think it's quite important to first turn back to the main objectives of the Hague-Visby rules. So when the drafters, what intention they had in mind when they were drafting the Hague-Visby rules, what they were seeking to achieve. So I'll first very quickly talk about that, and then I'm going to move on to some very interesting recent cases, English cases, on the interpretation of the Hague-Visby rules. So first, the main objective. So what they were thinking when drafting the Hague-Visby rules, there seems to be two main objectives I think they had in their mind. So the first one is, as we all know, to redress the imbalance between the cargo interests and carriers. Prior to the Hague rules, we all know that carriers were introducing sweeping exclusion clauses to relieve themselves of liability for any cargo, damage, loss, howsoever, whatsoever occurred. And that obviously had to change because in some jurisdictions, these clauses were enforceable, whereas in some other places, these clauses were struck down as invalid. And obviously, it was essential for countries to get together to set some uniform rules to govern contracts of carriage. So the major thing, obviously, that the drafters had in mind was to strike a fair balance between the carriers and cargo interests. Now, the other one is, I think, also quite important, and I also mentioned that during my short speech on the first day of the conference, the whole picture. So when we have got rules in place, it's also quite important for us to assess, examine, whether they actually make sense and whether they actually facilitate the development of the spread of the network of insurance. So we don't just have carriers and cargo interests in the picture, we also have insurers, and they actually have got a very important role obviously in the shipping industry. So how these risks of carriage are allocated, what are the risk sharing arrangements that are in place, whether they actually make sense when we take a look at the rules in place, whether there is the harmony between those arrangements and the rules that are in place. So I think that it was also important for the drafters when they set the rules, whether the mechanism, the system in place, whether the risk allocation in place, whether they work effectively and with some certainty when they set some liability rules for the carriers. So looking at where we are now, again, obviously, the crucial question we ask ourselves is, are those objectives still met? Or do we now need a new convention? So when we look at the balance between the parties, can we still see that balance? How about the risk arrangements, whether the insurance arrangements, fair allocation of risk, do we see those things in place still? Many of you might well say no, and you obviously have good reasons for it. We are talking about a very simple set of rules, Hague-Visby rules. They're too simple. They don't cover much. And there are always questions about their interpretation because of the ever-changing shipping practices. We always get some novel issues, legal issues that will need to be dealt with. And you might well say, well, I don't like this simplistic approach taken by the Hague-Visby rules, because everything has now changed. Containerization, electronic transport documents, we now have got mass on the horizon. This is not going to work. We really need to have something new. And that's quite understandable. But obviously the challenge there is to get together, find a time to draft something that will make sense to everyone and that will be acceptable to everyone, and then getting all countries ratify that. That's probably going to take a lot of time. It may well worth the effort, but there is a lot of work to be done there. But we also have to see the limitations that, obviously they do exist in the Hague-Visby rules. They are for carriage of goods by sea, to regulate contracts of carriage of goods by sea. And the temporal scope of application of the Hague-Visby rules, if you take a look at the articles here, you can now see on the slide, quite narrow, quite limiting. And that is why in Rotterdam rules, we had the C+ maritime plus regime proposed. If you look at what the Hague-Visby rules intend to cover in terms of its temporal scope of application, it is indeed quite narrow. So take a look at Article 2. So it refers to governing every contract of carriage of goods by sea. Particular emphasis there is placed. Obviously, the purpose there is to limit the scope of its application. It's in relation to loading, handling, stowage, carriage, custody, care, and discharge. So quite limiting. And think about the carriers' roles this day and age. They of course expand, and they need to deal with cargo before loading. They will have some carrying duties, arrangements, and everything post-discharge. And also contract of carriage. So what is contract of carriage? So again, contracts for carriage are excluded from the scope of application of the Hague-Visby rules. So if you need to have a contract of carriage where you have got a person who is happy to assume responsibility to carry goods as a carrier, so it shouldn't be a person there to arrange carriage for you. So that's another limitation that we see in the Hague-Visby rules. And consider also, again, Article 1E, again, defining the period for the mandatory application of the Hague-Visby rules from the time when the goods are loaded until the time they're discharged. And the word discharge is more or less all over the place. When delivery, you don't actually see much reference to that. Only in Article 136 you see a reference to that. So what are the problems with that? So there are lots of problems, lots of limitations. This is just to support my point that yes, Hague-Visby rules are simple. Yes, they are short. Yes, it has limitations. And when we need to deal with the problem of limitation, when we have the need to stretch these limitations, what we can do. And this is really all about that point, just to illustrate how those limitations can be stretched, whether there is any room for stretching any further. So think of Article 3.8. So this is a time-bar provision. This is the place where the convention only speaks of delivery, not discharge. So obviously here note there are linguistic nuances between delivery and discharge. So discharge is a physical act, operation to remove the cargo from the ship, while delivery is a legal concept whereby possession of the goods are handed over to someone irrevocably by the carrier. So they're not the same thing. And because of the active roles that carriers do play this day and age, usually delivery does take place after discharge. So that leaves us with the question of, so what's going to happen if carrier does something wrong after discharge? We want to give cargo interests the protection that they want vis-a-vis the carriers. But if the carriers mess things up after discharge, what's going to happen to the protection there? Will there be any overriding mandatory protections in favor of the cargo interests? So some interesting views were taken on that point, and the reason why this question is important is particularly, it shows its importance, particularly in the context of misdelivery, because delivery and discharge may not always happen simultaneously. And when delivery takes place after discharge, and when the cargo is misdelivered, should we still apply the rules? Should the rules have mandatory application when you have got a misdelivery case in those circumstances? So some scholarly views I have cited in the PowerPoint slide. So bills of lading, the renowned editors of bills of lading, Akins and Richard Lord QC, and others. And so they refer to Carver's implied term argument, arguing that the post-discharge period should still, nevertheless, be governed by the Hague-Visby rules. They should be implied into that phase to give some protection to the cargo interests. So this was referred to as Carver's implied term. So although, well, yes, Hague-Visby rules speak of loading discharge, after that, the rules do not govern. If you just look at the wording there and the express provision provided therein. So Carver's view there is to expand the scope of application of the Hague-Visby rules beyond discharge and beyond the preloading stage, arguing that, well, we can imply something. What happened? So you won't probably believe, but we're actually dealing with this problem. Maybe in your jurisdictions, you have a very easy answer to that question. But this issue is a very important issue, a very sort of current issue in this jurisdiction, because it's currently before the Supreme Court. So the hearing took place this year during the summer. And now we are waiting for the judgment. I've just checked the Supreme Court website. The judgment is still not there, so I can confirm that there is no Supreme Court judgment on the point. If I may just report the Court of Appeal judgment on the topic, the view, the current view, before we see the Supreme Court's view on that, is that Article 3.6, which is the time bar application, should apply to misdelivery claims. So when misdelivery takes place after discharge, despite all the restrictions that you see in Article 2(1)(e), referring to loading until discharge, they are not there to limit the application of Article 3.6 of the Hague-Visby rules, which is about time bar. It's quite an interesting case. So yes, it's a bit technical. Yes, it's just one point about the Hague-Visby rules. But the reason why it's important, I think, for us to think about is because of the court's approach to this matter, the commentary there, and the use of travaux preparatoires there, to give some international angle to the views taken there to support the decision. So that is why it's quite an interesting case to look into. So looking at the facts, quite known, definitely not uncommon. So you have got a misdelivered cargo. Bank was shown as the holder of the bill of lading because they were financing the underlying sale contract in that case. And once they were unpaid, they wanted to assert their rights against the cargo, but by that time, the goods had already been misdelivered to a wrong party. And 2 years after discharge, the bank, as the holders of the bills of lading, commenced arbitration proceedings against the carrier. They actually messed with the identity of carrier. So they actually initially sued the wrong person, thinking that the wrong entity, thinking that they were the contractual carriers. So they had no option but then to just try the parties. And eventually they found the right party. But by that time, already 2 years passed. So not really a nice story for a lawyer representing the bank. So that is what happens in this case. So the carriers contend that the liability was extinguished with reference to Article 3. So once obviously 1 year passed, with reference to Article 3.6, the carrier's argument was the time bar provision applied to this case. So their liability is extinguished after the passage of 1 year. So they obviously cited Article 3.6 to support their submission on that. Another important fact here to mention is that the bill of lading was in Kongen bill form, 1994, and there reference is made to the carrier's position, legal position. So the provision, particularly clause C2, seeks to relieve carriers of liability. So clearly stating that the carriers shall be not responsible for any loss of the damage happening after post discharge. So how is that relevant? I will explain now because as we look into the argument submissions in some detail. So Carrier's argument was Article 3.6 was applicable. So a number of reasons. So Carver's implied term, they relied on that. Further, alternatively, they also relied on the wide words used in Article 3.8. And that's quite right. Article 3.8 is the only article mentioning delivery. The rest of the Hague-Visby rules only speak of discharge. So that may well mean that drafters had delivery in mind when drafting that. So that's obviously one thing that they mentioned. Finbank, so the cargo interest perspective was obviously different. So their main submission was that the claim was not time-barred because the Hague-Visby rules are not applicable. And main, obviously, argument there is to say that when you look at how the contract of carriage is defined, the scope of application of the Hague-Visby rules is defined. So Article 2, Article 1E, reference there is made to the time relating to loading, discharge, carriage. So the bank's argument is that these provisions limit the application of all the articles in the convention, so they should only be applicable, all of them in their entirety should only be applicable during the loading until the discharge, completion of discharge, so only during that period. So that was their argument. And further, alternatively, they said, well, if you really find Carver's implied term quite an interesting and a good one to adopt, we think that Carver's implied term doesn't apply because Congen bill form clause 2 disapplies. So it excludes the application of the Hague-Visby rules because of its wording. So very interesting arguments were raised. So the decision of the Court of Appeal on that was the rules were held to be Article 3.6 was held to be applicable. And the court's approach there was quite a good one and quite an important one to mention. And they relied heavily on the travaux propriétaires. So considering what the drafters wanted to achieve, looking at the discussions of the delegates, what their intention was. So looking beyond the words used there to find out what their real intention was. And I think this is quite a good way of approaching, because that obviously shows that when you are trying to stretch the limits of the Hague-Visby rules, trying to find a solution to a novel situation, which may well happen in the future, how the courts are going to tackle that. These recent cases clearly show that in the interest of certainty and uniformity, heavy reliance is placed on what the drafters intended. And that can solve many of our problems, because that obviously will help us give some purposive interpretation to the rules, that will help us form some uniform solutions to the problems that may well happen anytime around the world, irrespective of the law applicable, irrespective of the forum before which the cargo claim may well be brought. So quite a useful thing to see, and quite a good approach to take. That's my personal view on that. So what are the other findings? So the decision of the Court of Appeal clearly shows that as far as Hague-Visby rules are concerned, considering the intention of the drafters, Article 3.6 should apply to misdelivery claims, even in cases where misdelivery takes place after discharge. And the main reason, so you might well think, well, what were the grounds, Melis? Well, they didn't buy the Carver argument. You may think why. I think that was quite a good one. But the Court of Appeal's view was, well, why imply terms? Implication of terms shouldn't be done so quickly, so readily, so easily. So they didn't buy that argument. Instead, they said, looking at the wide words used and the intentions behind them, we need to interpret Article 3.6 accordingly, giving it wide coverage, also covering misdelivery claims happening after discharge. So that was their main reasoning. Clause 2, they said, doesn't disapply anything. And I think that's also quite a correct point. They were quite right in saying that, because if you look at the wording of clause 2, it just says carriers shall not be responsible whatsoever. It actually doesn't tackle the question of application of the Hague-Visby rules. So you can't really there see any clear intention to exclude contract out of any part of the convention. So I think it was quite right for them to take that approach. So what we see in that case, so just to sum up, so let me just do it again. So trois propriétaires, intention of the drafters of the Hague-Visby rule. So those were the essential ingredients for the court's decision. And a similar view was also taken in again, a very recent case, but this time just first instance decision. But everybody actually thinks that this is the decision that actually sets out the rules for interpretation of the package implementation. Before this case, there was another case, which was the Limnos. And Mr. Justice Burton there actually sets an international view for the purposes of interpreting the Hague-Visby rules. But the result that he reached, many people thought was not appropriate, was not the right way forward. So if we were to compare the approaches, they both had the intention, both judges had the intention to take an internationalist view for the purpose of promoting uniformity, providing certainty. Which one achieved? It looks like the recent one, the Thorco lineage, appears to achieve that more. If you also look at the judgment, there is more emphasis there placed on the delegate's intention, the drafter's intention. There is some more work done actually that assisted the courts when reaching the conclusion that they reached. So what's the core issue in these cases? Package implementation, what it covers, whether it only covers physical losses or damages to goods, or whether economic losses are also subject to the package implementation. It will be wonderful to know what the situation is in other jurisdictions. I wish I could have the opportunity just to be there, perhaps during a coffee break or something. We could just have a chat, because there are different ways to interpret things, and as we are seeking uniformity in these important areas of law, it will be very useful to know what other courts think in other jurisdictions. So that would be really nice to know. So the English law position previously, with reference to the Limnos decision, which was a first instance decision, economic losses were not covered. So that was the initial approach taken by the decision in the Limnos. In that decision, the view taken was that only physical losses or damages would be subject to the package unit limitation. So in that case, there was a partly damaged cargo, and because of that partial damage, the total value of the entire cargo depreciated, and the cargo interests quite rightly wanted to get compensated for that. So the main question there was whether for the calculation of limitation of liability, whether the economic losses should also count. So the answer there was Hague-Visby rules, because of the wording there, shouldn't be stretched to cover economic losses. That view was changed now. It's now changed in Thorco lineage. And in this very recent case, the court took the view that economic losses should also be covered by the rules. So what economic losses they were dealing with? So general average costs, so salvage costs as well, on shipment costs. So there were some issues with first the vessel, so cargo there was damaged, and so in Korea, where the vessel was being repaired, some part of the cargo was transshipped onto another vessel. So there were lots of disposal costs, on shipment costs, and salvage costs as well. So whether these costs, together with the physical loss or damage, whether they would be subject to the package limitation, the answer to that question was yes. How the court reached that view, focusing on the intention of the drafters Hague-Visby rules. So trois propriétaires were the key for the decision. So intention of the drafters. So that was the key thing in that case. so I have already mentioned Limnos and what that is about. So in these two cases, so in Thor lineage and Limnos, what we see and the main takeaway from these cases is that we still, obviously, because Hague-Visby rules are quite brief, maybe too simple, maybe too short, and that is why we're usually left with so many questions, so many question marks when we deal with a real cargo claim. And obviously that means that these issues may well need to be brought before a court. But what the courts try to do here is try to, obviously, in the interest of reaching certainty and uniformity, if there is any room for expansion, if there is any room for stretching, any flexibility, that is given in accordance with the drafters of the convention. And that is obviously a good thing, to bring some certainty, to try to anticipate what the likely result outcome is going to be in a particular case. So I think that's quite an important approach, and quite a good one that has been recently taken by the courts. But what happens if the Hague-Visby rules don't actually mention, if they're completely silent about a matter that is crucial for us when we deal with cargo claims? So to that, I have another example. So Volcafe. So in the first instance, when looking at Limnos and Thor lineage, we were dealing with a situation where the rules actually stipulate in an article, but we can't be quite sure about how to interpret it. There is some ambiguity there, some limitations, restrictions there appearing, and we're just left with the question of whether we should stretch the words to cover X, Y, Z. Yes, this is a different exercise. There are so many areas where the Hague-Visby rules are completely silent. So what the course approach should be, again, this is obviously the overarching question is whether Hague-Visby rules are okay, whether they're sufficient. We will be seeing even more and more questions that will not be covered by the Hague-Visby rules. How are the courts going to tackle? So think of the question here in Volcafe. This is a Supreme Court case where the Supreme Court had to deal with the question of burden of proof. Who had the burden to prove when you have got a potential breach of Article 3.2? Should the cargo claimant establish breach of Article 3.2, or should it be on the carrier's shoulder? Should they bear the burden of disproving their fault? Nothing is stated in the Hague-Visby rules. And if we want uniformity, it's quite important to have a proper approach to questions like this, because we don't want each and every legal system country to come up with different solutions to that. Because obviously there is nothing in the rules. English court here in this paragraph in Volcafe clearly acknowledges that it is okay for them, legitimate for them, to look into the common law rules on burden of proof. So obviously they discussed the principles of bailment, which is quite relevant and important for the grounds of the decision taken here. But even in that kind of situation, you will see, so if you just look towards the end of the paragraph, you will see some reference made to other jurisdictions. So how the courts in other jurisdictions approach this matter. And again, I think this is a good thing in the interest of uniformity and certainty, just to make sure that there are no striking differences between the solutions that we propose for cargo claims in different jurisdictions. So again, a rather internationalist view, not exactly, maybe, but it's obviously you there see the spirit that we need to make sure that you need to be at least aware of what other jurisdictions handle these things, because we deal with a question that is by and large governed by an international convention. And even in areas where the convention is silent, we need to hold that international spirit to ensure that what we think is in line with what other countries think. I think that's a very, very good approach taken there as well. So the main takeaway is, I don't think any convention can actually help us decide every individual novel cargo claims that we will have to handle. It's quite impossible. And it doesn't matter how rigorous the convention is, how lengthy that is, how detailed that is, there will always be questions on interpretation. And I think it might be sensible, that is why at this point, to just check and see how we're going to live with what we have got when all these new changes take place, when MAS starts their commercial operation. I think it might be useful just to check and see how badly a new convention is needed, or maybe not, because there are ways, as these cases show, if you just consider the nature of these questions, you may well think, well, these questions should have been answered by now. But this is obviously what the law is, and parties don't spend money if they don't desperately need to do so. And that is why many of the legal questions, they can't be brought before a court or arbitration, because all these things are quite costly. So it may obviously take some time for some disputes to be brought before courts, arbitrators for decision. And I think it's a quite healthy thing for the things to evolve this way. And because it obviously gives us an opportunity to assess and reassess where we are and where we're heading, and whether we're actually in need of something. And looking at the current trend that we see taken by English courts, I think these are welcome. And I think it's, and I'm sure in your jurisdictions, similar approaches are taken. And I think they're all good in the interest of uniformity and certainty. Some very strong views obviously can be argued about, let's say, abolition of nautical fault exception, or time bar perhaps may be extended, maybe package unit limitation could be higher. Well, there are more obviously substantially that may well require some discussions. But when it comes to other technical issues, and when we have got concerns about, well, this old convention, whether it can actually apply to novel issues that will arise when we have got MAS in operation, it may not well be the case. So it may well be possible for these provisions somehow to still be stretched, considering the main purpose behind these conventions, behind this particular convention. Some solutions can be achieved. So that will be my main theme, so main conclusion, that main takeaway that I think that could be taken and that can be obtained from these decisions. So thank you very much for listening.